Senator from Washington.
Madam President, I want to thank my colleagues from Connecticut and Wisconsin for their strong voices and support for a woman to make her own health care decisions in this country. And I appreciate them being here today to talk about that and to note with me that 41 years ago, last week, just about 400 yards from where we are standing today, the course of history for women in the United States was changed forever. After over a century of struggle, a new generation of American women had access to safe and legal abortions. With one case, American women had gained the ability to make their own decisions about their own health care and their own bodies. At a time when some members of this body were far too young to remember, women stood up to the restrictive laws of states and the federal government and to the men who at that time wrote them. Now, Madam President, I'd like to think that after 4 decades, many of those who want to make women's health care decisions for them have come to grips with the fact that Roe v. Wade is settled law. But unfortunately, that notion is quickly shattered with one look at our legislatures across the country and efforts right here in Congress. In fact, tomorrow, the House of Representatives is slated to vote on their misleadingly named No Taxpayer Funding for Abortion Act. That bill severely undermines a woman's access to insurance coverage of comprehensive health care and fails to allow her to get the care she needs even when her own health is at risk. It's nothing more than an attempt to eliminate access to abortion services while restricting a woman's ability to make personal decisions about her own care. I guess we shouldn't be surprised, Madam President. The truth is that the tide of these politically driven, extreme, and unconstitutional laws continues to rise. In 2013, our nation saw yet another record-breaking year of state legislatures passing restrictive legislation barring women's access to abortion services. In fact, in the past 3 years, the United States has enacted more of these restrictions than in the previous 10 years combined. That means that now, more than ever, it's our job to protect this decision for women, to fight for women's health, and to ensure that women's health does not become a political football. For that reason, today, I will, along with 18 other members of my caucus, file a brief with the Supreme Court of the United States in the case of Hobby Lobby Stores, Inc. versus Sebelius. And just like the many attempts before this case, there are those out there who would like the American public to believe that this conversation is anything but an attack on women's health care. To them, it's a debate about freedom, except, of course, for the freedom of women to access their own care. It's no different than when we are told that attacks on abortion rights aren't an infringement on a woman's right to choose. They are about religion or states' rights. Or when we are told that restricting emergency contraception isn't about limiting women's ability to make our own family planning decisions, it's about protecting pharmacists. Or, just like last week when we were told that a certain former Republican governor's comments about women's libido was, quote, tone issue, rather than a direct reflection of the Republican Party's misguided and arcane policies. The truth is, this case is about contraception. This is an attempt to limit a woman's ability to access care. This is about women. Allowing a woman's boss to call the shots about her access to birth control should be inconceivable to all Americans in this day and age, and takes us back to a place in history when women had no voice or no choice. In fact, contraception was included as a required preventive service in the Affordable Care Act on the recommendation of an independent, nonprofit Institute of Medicine and other medical experts because it is essential to the health of women and their families. After many years of research, we know ensuring access for effective birth control has a direct impact on improving the lives of women and families in America. We have been able to directly link it to declines in maternal and infant mortality, reduced risk of ovarian cancer, better overall healthcare outcomes for women, and far fewer unintended pregnancies and abortions, which is a goal we should all share. But what's at stake in this case before the Supreme Court is whether a CEO's personal belief trumps a woman's right to access free or low-cost contraception under the Affordable Care Act. Madam President, every American deserves to have access to high-quality health care coverage regardless of where they work. And each of us should have the right to make our own medical and religious decisions without being dictated to by or limited by our employer. Contraceptive coverage is supported by the vast majority of Americans who understand how important it is for women and families. In weighing this case, my hope is that the court realizes that women working for private companies should be afforded the same access to medical care regardless of who signs their paycheck. We can't allow for-profit, secular corporations or their shareholders to deny female employees access to comprehensive women's health care under the guise of a religious exemption. It's as if we're saying that because you are a CEO or a shareholder in a corporation, your rights are more important than your employees who happen to be women. That is a very slippery slope that could lead to employers cutting off coverage for childhood immunizations if they object to it, or prenatal care for children born to unmarried parents if they thought that was wrong, or an employee's ability to access HIV treatment. Madam President, I'm proud to be joined in this effort by 18 other senators who were here when Congress enacted the religious protections through the Religious Freedom Restoration Act in 1993, and who also were here when Congress made access to women's health available through the Affordable Care Act in 2010. They are senators who know that Congress never intended for a corporation or furthermore its shareholders to restrict a woman's access to preventive health care, because we all know that improving access to birth control is good health policy and good economic policy. We know it will mean healthier women, healthier children, and healthier families, and we know it will save money for businesses and consumers. So today, we are taking another step forward to uphold the promise we made to women and provide this access broadly. And I believe that our nation will be better for it.